Hello, it's Philip Taylor speaking from Richmond Green Chambers, and today I'm looking at a book from the Oxford University Press, and it's in an interesting and little difficult area of law. It's called A Restatement of the English Law of Unjust Enrichment, and it's this book here. It's only a small book, a couple of hundred pages. You can see the back is very detailed, explaining what unjust enrichment is about and who's written the book. It's been written by Andrew Burrows, well-known eminent lawyer, assisted by an advisory group of academics, judges and practitioners. The book itself is looking very carefully at what unjust enrichment actually means. The index at the back is very useful. There's also a very substantial bibliography. In fact, it's the table of cases that you have there at the back rather than the bibliography as such. What you do have, though, are some very useful headings within the actual contents pages itself to cover the general points: enrichment at the claimant's expense, when the enrichment is unjust, defences and restitutionary rights. And what you do have in the book itself are chapters and paragraph numbering at the sides to assist. And then there are lots of examples of the type of unjust enrichment that you might get. The title we've given this book is Unjust Enrichment, a newly recognised and particularly difficult area of law fully explained. And the point is that the law of unjust enrichment is a newly recognised subject, according to Andrew Burrows. And what he's produced here is a thorough and scholarly yet eminently readable work which expounds on a particularly abstruse and therefore fascinating area of law to many. Unjust enrichment can be reviewed, we think, as an emerging modern equitable doctrine to cover the main substantive law areas of contract and tort, with specific reference to what we used to call restitution. In other words, putting the people back into their original positions, but at the same time making sure they don't benefit as a result of it. Call it an exercise, if you will, in the availability and use of an updated equitable remedy. Obviously it's now called unjust enrichment, which is where we are actually much more at home with the expression. It could be argued that this term is more or less self-explanatory, in that it all too often refers basically to people taking money for themselves on an intimidatingly wide range of pretexts, especially in contract and tort, mainly with many of them with quite ingenious schemes. So the purpose of the book is to unravel the intricacies of the original legal principles and to look at it in its modern setting. And that's what the restatement exactly does. Unjust enrichment is carefully and precisely defined in this work, and you can read the book actually from cover to cover quite easily because it's only a very small book, but there's a great deal of detail in it and it sheds a lot of light on a number of conundrums. This, in our view, is an important book of direct relevance for practitioners, academics and the judiciary. Certainly something I think the Judicial College would be interested in, and the restatement is supported throughout by full commentary and illustrative cases, both real and hypothetical. I think it's a great additional resource for people who are faced with this type of problem, where in fact there is an imbalance in terms of what one of the parties has achieved as a result of problems in the litigation. So I'd like to thank Mr. Burrows and his team very much, and to OUP for producing what is an excellent short work. Thank you very much. Bye-bye.